Judgment in the matter of Warner-Lambert Company LLC versus Generics Limited, trading as Mylan and another.
Lord Sumption will summarise the reasons for the judgment.
A patent confers a time-limited monopoly on its holder to exploit a novel invention. To justify the monopoly, the patentee must disclose the invention so that the public can freely use it after the patent has expired. This appeal is the latest battle in the long-running war between the holders of pharmaceutical patents and the generic drug companies which use their invention to manufacture in competition with them once the patent has expired, or earlier, if they can show that it is invalid. The appellant, Warner-Lambert, is the patentee in this case. The respondents, Actavis and Mylan, are generic manufacturers. The drug in question is pregabalin, a compound used for the treatment of epilepsy, generalized anxiety disorder, and neuropathic pain. An important objective of modern pharmaceutical research is to discover new medical uses for known chemical compounds. This often involves expensive research and will only happen if patent protection is available. There are, however, two problems about this. First, the chemical compound itself cannot be patented because if it is already known, it will not be novel. The only thing that is new is the discovery that it has a second use. Secondly, the new medical use cannot itself be patented because for ethical reasons the Patents Act forbids the grant of patents for a method of treating the human or animal body. The solution to this problem is what is known as a Swiss form patent, because it was devised by the Swiss Intellectual Property Office in 1984. They announced that they would henceforth be prepared to issue patents in the form the use of compound X in the manufacture of a medicine for the treatment of indication Y. Their lead was followed by the enlarged Board of Appeal of the European Patent Office and the English High Court. In English law, Swiss form patents are patents not for the compound itself or for the treatment method, but for the process of manufacture for the purpose of treating indication Y. This concept is a valuable addition to the portfolio of intellectual property rights protected by law, but it is not easy to fit within the traditional framework of patent law. Two main issues have arisen in this case. One is about the requirement of sufficiency, and the other about infringement. Before coming to these concepts, I should say something about pregabalin. It was originally invented as a treatment for seizure disorders, mainly epilepsy. It is marketed by Warner-Lambert, a company in the Pfizer group, under the brand name Lyrica. They were the proprietors of a European patent for pregabalin, which expired 5 years ago in 2013. In 1996, Warner-Lambert applied for a second European patent for the same compound, which was eventually granted. This claimed the use of pregabalin for the treatment of pain, and in particular neuropathic pain. Neuropathic pain must be distinguished from inflammatory pain and other forms of nociceptive pain, which result from the localized application of mechanical pressure, chemicals, or extremes of temperature. Neuropathic pain is caused by damage to or dysfunction of the nervous system. Peripheral neuropathic pain is localized pain arising from damage or dysfunction of the peripheral nervous system. Central neuropathic pain arises from damage or dysfunction of the central nervous system, for example, as a result of a stroke or multiple sclerosis. Neuropathic pain, and especially central neuropathic pain, is notoriously difficult to treat. Warner-Lambert's second-use patent is still current. The result is that rival manufacturers or marketers, like the Respondents, are free to manufacture pregabalin for the treatment of seizure disorders, for which the patent has expired, but if Warner-Lambert's second patent is valid, they cannot manufacture it for the treatment of pain. I shall deal first with the issue of sufficiency. Sufficiency is a condition of the validity of a patent. Broadly speaking, the condition is that the patentee must have sufficiently disclosed the invention to the public in the text of the specification. In the case of Swiss form patents, where the compound is already known, This has been held to mean that the patent must disclose some scientific reason for expecting it to work in its new use. The patent need not definitively prove that it works or how. It need only show that it is plausible to suppose that it may well work. This is not an exacting test, but the judge, Mr. Justice Arnold, held that Warner-Lambert failed it. This was because he interpreted the patent as claiming a monopoly of the manufacture of pregabalin for all pain, including all neuropathic pain. In his view, although the patent specification showed sufficiently why pregabalin could be expected to work with peripheral neuropathic pain, it didn't show any scientific reason why it could be expected to work for central neuropathic pain. Since the patent covered both, the disclosure was therefore insufficient. The judge refused to allow Warner-Lambert to amend their case after the judgment so as to restrict their claim to peripheral neuropathic pain, thus confining it to what the judge found to have been sufficiently disclosed and saving its validity. He regarded that as an abuse once they had lost in a lengthy trial. The Court of Appeal substantially agreed with him. On this issue, the Supreme Court unanimously agrees with the courts below that the patent claimed a monopoly of all neuropathic pain and that the judge was right to refuse to let Warner-Lambert amend their patent. Since Warner-Lambert do not challenge the judge's finding that the specification made insufficient disclosure as regards central neuropathic pain, it follows that the patent was invalid for insufficiency of disclosure. The specification was insufficient. On that ground, we dismiss Warner-Lambert's appeal. A majority of us goes further than the courts below and allows the cross-appeal of Actavis and Mylan. They held that the patent specification was insufficient not only in relation to central neuropathic pain, but in relation to peripheral neuropathic pain as well. The specification contains no experimental data showing any reason why it can be expected to work for any kind of neuropathic pain, or indeed for anything other than inflammatory pain. Experimental data are not required, but if there is none, then there must at least be some theoretical reasoning suggesting a scientific reason why it may work in the new use. For example, it may have some chemical property which would lead a skilled person to anticipate that it might well work, or some unifying principle which relates the product to some other product which could be expected to work. The evidence in this case was that the most that the skilled person could deduce from the specification about pregabalin in its new use was that it would be worth trying to see whether it worked. To say that something is worth trying is not a sufficient disclosure of anything inventive. I turn to the second major issue, infringement. This does not, strictly speaking, arise because we have held the patent to be invalid. However, the issue is difficult and important, and it was fully argued. We have therefore dealt with it. The Patents Act, so far as relevant, provides that there is an infringement of a process claim by anybody who disposes of or offers to dispose of or uses or imports any product obtained by means of the process. It is common ground that this is a strict liability provision. If the product was obtained by the patented process, then anybody dealing in it, however innocent, and even if he acts in good faith, is an infringer. The courts below disagreed about how this should be applied to a second-use medical patent. The problem is this: if the generic company manufactures a drug for a patent-expired use, what is to stop it being prescribed by doctors or dispensed by pharmacists for a patent-protected use? And if it is, has the patent been infringed, and by whom? Mr. Justice Arnold considered that the generic manufacturer infringed the patent only if he manufactured the product, only if when he manufactured the product, he was mentally targeting the patent-protected market. In this case, the market for pregabalin for treating pain. He held that there was no targeting and so no infringement. The Court of Appeal, by comparison, thought that the generic manufacturer infringed the patent if he ought reasonably to have foreseen that some part of his output would be sold for the patent-protected use, unless he had taken all reasonable steps to confine it to the patent-expired use. The majority of this court considers that neither of these tests is correct. The problem about the judge's test is that it means that the extent of the monopoly, and therefore the liability not just of manufacturers, but of wholesalers, distributors, and retail pharmacists, depends on the alleged manufacturer's on the manufacturer's state of mind at the time when he manufactured the product. If he intended that any substantial part of his output would be used for a patent-protected use, all of those who handle it commercially en route to the patient are infringers, although the manufacturer's state of mind cannot be deduced from the terms of the patent or otherwise discovered. They would be liable not on account of their own state of mind, but on account of somebody else's state of mind to which they were not privy. This would be a unique and extraordinary concept in the law. The problem about the Court of Appeal's test is that because the manufacturer has no control over the use made of the product once it has left his hands, it is in practice almost certain that some of his output will be used for a patent-protected purpose, and he must know that. It would follow that the whole of his output would infringe, and so would anyone handling it commercially. The Court of Appeal's qualification that this would not apply if reasonable steps were taken to prevent use for patent-protected purposes does not work. This is because the pharmaceutical world knows that whatever steps are taken to confine sales to the patent-expired market, there will always be some significant leakage into the patent-protected market. In the view of the majority, the true test depends essentially on the use for which the drug is overtly sold according to the label on the product and the enclosed patient information leaflet. Of the three members of the majority, Lord Mance leaves open the possibility that in certain exceptional circumstances the designated uses in the label and leaflet might not be conclusive, and therefore leaves open the question whether there would have been an infringement in this case. The other two members of the majority consider that on the judge's findings there would have been no infringement. The minority, Lord Briggs and Lord Hodge, agree that there would have been no infringement, but for the different reasons given by Mr. Justice Arnold. In the result, Warner-Lambert's appeal must be dismissed, and Actavis and Mylan's cross-appeal will be allowed.